The
meeting is now called to order. We have a quorum. Members, agenda item number 1. The administration has provided a paper in response to the question raised by our legal advisor on the 22nd of May. The paper is CB1 914-1415-01. So would the officials introduce the paper, please? Yes, Mr. Chairman. In fact, the answer is very simple. We just take note of the observation made by the legal advisor in respect of the case. In fact, the content is unrelated to insurance. It is about agency law. If the agent has acted ultra-virus, then the contract will become void. As for the fourth point in the letter, we don't believe there is a need to set out in the law what is the authority, the scope of authority, because the scope has been clearly spelled out in the contract. Any questions from members? Then let's move on. If there is no question, and then we'll move on to look at the CSAs. In fact, at the last meeting, we have studied some of the CSAs. Members may refer to CB1 877-1415-04. The administration has also responded to the questions raised by a legal advisor on the 31st of March and 5th of May, and the responses are incorporated in paper CB1 858-1415-04 and 05, and these issues will be dealt with because there will be CSAs dealing with these issues. We will start at page 11 of the Chinese version. Legal advisor. We are now starting from page 11. On the left-hand corner, there is a bracket T. When you see the word T, it is a textual amendment. This is just to add the Chinese word cup or N in English. And then over the page is page 19. On the left-hand side, there is also a T, which is a minor amendment. And then pages 25 and 26. This is about the definition of the controller. In respect of the controller, there is no change in definition, but this is just to clarify the different areas of to define more clearly, and therefore consider with regard to the amendment of controller, we have made given an annex, and your members may refer to the annex. It is a markup copy, which is above on top of the original. We add the CSA. If members may refer to the annex, that is 0005. You can see this on top of the page.
呢個。係啦。
咁0005頁嗰個修訂咧，就係上一次會議已經講咗㗎啦，就係將原先嗰個修訂咧，就係撥到去第9條嘅。咁跟住揭去第2版嗰度咧，我哋做咗一個 mark up 咧，就係喺右手邊咧，就係睇到咧，我哋就會係將原先左手邊條文有關喺第9條裏邊控權人嘅涵義咧，就係寫過一次咧，就喺右手邊嘅。咁其實主要嘅內容咧係一樣嘅，例如就控權人係包呢個常務董事啊、行政總裁，又或者係控。
Put it on the right-hand side. That includes the executive director and also those who control of who is in control of 15% of the shares, and we've set out the applicable company. If you may turn over the page at the end, you can see that applicable company means a company making an application under Section 7 or an authorized insurer. Now, since you are in the appendix, to avoid jumping around, let us move on to the relevant the amendments in the appendix. You can see the page number 0041, and that is Section 13A. That is a definition for controller. Therefore, we have moved we propose to move a CSA. That means a controller is executive director or chief executive of the insurer, a managing director or chief executive of the insurer. We just put the definition here. Yes, just a moment. Mr. Sin Chung Kai. In the markup copy, there is a B. It does not include a manager. You single that out. Why you single that out? In fact, a manager refers to a takeover. The manager is appointed by the IIA to take over. The manager is appointed by the IIA to take over the business. The controller must have control of the company. The manager, after taking over, has control, but we don't want to include manager in the definition of controller because this is just a short-term arrangement when the company is in liquidation or winding up. I don't understand. Now you say that in relation to an authorized insurer which is incorporated outside Hong Kong, blah, blah, blah. Is it a general definition? You exclude the manager. Now in receivership it's just a transitional stage, but the controller can be demoted to a manager. Now, the controller is a managing director or a chief executive of the insurer or who has control of a certain percentage of the votes. And then in the definition, there is also a definition of manager. In respect of 35(2)(b), the IIA will appoint a manager under the provision. It's not a manager called by an insurance company or by anybody. That is a specific definition in the ordinance. This manager is not other managers. You cannot just use the term manager in whatever ways you like. The manager is the one appointed by the IIA, now by the IA, by us. I appoint the manager. In the future, it will be the IIA who will appoint the manager. That is a special definition. Is it okay? Please move on. In the appendix, members will continue to see technical amendments they are in response to, or they are consequential to the other amendments. If there is no further questions, let us refer to Annex A. We should be on page 30 on the right-hand side. On page 30, there is a bracket 3. This is in response to the requirement of the the Commissioner for Personal Privacy. And then we move on to page 31. There is a T showing an amendment. And then we are on page 32. Just a minute. Just a second, please. Page 31, subsection 4. There is an amendment. But in terms of wording, I discussed with the authorities. If you may refer to 34.4, there is a similar one which is equal to 31.4. Now there is a change. Instead of putting in the front, unless it is put at somewhere else. And there are similar provisions. I have consulted the drafting, drafting section. Page 36 also has this situation. They should adopt 34.4. They should adopt the method of 34.4. Now there are similar provisions, but they are not consistent. The legal advisor is right. On page 34, it says, 保監局除非信納. We will follow the flow, the wording of page 34 of the Chinese version. Is it okay? So this is only an amendment to the Chinese version. It's just a textual amendment. All right, please go on. Please go on. And now there is another part which is similar. If you may refer to page 31, clause 9A. This is also in relation to the Chinese version. Members may refer to page 51 of the Chinese version. In fact, they're discussing the wording of the Chinese version. And it is not in respect of the English version. We have confirmed of the drafting section. The wording in Chinese is similar to the one on page 51. Bracket 3 capital F. There are similar provisions. So you need to make the provisions consistent. Yes, please move on. We are on page 32.
On the top right-hand corner, you find bracket 4. And actually, this is in response to a member's suggestion at an earlier meeting. When there is a breach of a commitment, a similar offense, then the licensee, the penalty for the licensee would be the same as, an individual who actually commits the same offense. So there is also an offense for continual offense. We may now turn to the next page, which is page 34, bracket 3, the word reasonably. I think this is has been put in response to the request by the privacy commissioner, and then under T there is a minor textual amendment. On page 35, you have a big bracket 4, and again for the offense, I think we've aligned the offense and the penalty for both the individual and the organization is aligned. And then page 36 again, the word reasonably has been put in, and also like the legal advisor pointed out, there is also a minor textual amendment. We now come to page 37 at the bottom left corner. Again, under bracket 4, we've aligned the offense and make it consistent. Pages 38 to 39, there's a group of amendments here, and this is actually in response to the International Federation of Insurance Supervisors, and that is the code number 8. That is, other than the intermediaries, in terms of controlling functions, we have to follow the guidelines provided by the International Federation of Insurance regulators. We have added, the internal compliance, actuarial functions, and so on page 35, we've added some functions in response to the request by the requirement of the International, Federation of Insurance Supervisors. On page 39, bracket 13, we have, I beg your pardon, we've added the word responsible to define, to clarify that the controlling officer, other than the person who exercises a controlling function, if he is responsible for let's say if some of the functions have been outsourced, if he is responsible for overseeing the functions which have been outsourced, then he is regarded to be, to have this controlling functions. And then on page 44, T is a textual amendment. Same for page 41, a minor textual amendment. Page 42, definition for definition controller, which I have already explained. Page 41, bracket 2 and bracket 3. So there is no amendment as it stands. I've confirmed with the law draftsman that the text, there will be a textual amendment so that the drafting will follow 13, the one in 13AG. Well, that has been confirmed. So could you, adjust this? Page 45, bottom left-hand corner, again, you find a minor textual amendment. Page 48, it's a realignment. We have bracket 2 here, and the definition of controlling officer is moved to the front. Person in control functions. And then page 50, on page 50, there is a series of amendments. If I may explain the amendments or the background for the amendment on page 50. At the moment, under Section 15 of the Insurance Companies Ordinance, the authorized person and the authorized insurer who is allowed to operate his business, the auditor, there are requirements regarding the actuaries and auditors appointed by this insurer. And the appointment of the actuary has to be recognized by the Commissioner for Insurance. On page 56, the amendment here is that we have clarified the procedure for the recognition of the controlling officers and the actuaries. But the original intention, I think in the original ordinance and in the bill itself, the intent has not been changed. If members go to page 51, we have stipulated under bracket 3A, that is the insurer must, by the date specified in the notice terminate the appointment of the person as an actuary of the insurer. Page 52, bracket 6 is the same group of amendment where we've added an offense. That is where the person contravenes subsection 3A or 3EA, there will be a fine. Next, we move on to page 53 and 54. The series of amendments are in respect of the appointment of the actuary, and these are technical amendments. For example, under 15 capital AB, this is the procedure stipulating that the IIA must give the person a right to make submissions. And then 15AC, at the time of application, the person submits false information. Then on page 54, we would provide for the penalties. Next, page 54, 55, and 56 and 57. The three groups of amendments belong to the same category. Here it is stipulated, I think in the original ordinance, it is stipulated that the insurer, I think if he needs to change the actuary, he would need to inform the Commissioner for Insurance. We stipulate here that if the IIA thinks that the actuary is not a fit and proper person, the IIA may issue a notice to the insurer objecting to the appointment. That's the amendment for page 56. On page 57, the amendment is in respect of a procedure that is, IA must submit the notice in writing, and that the person should be able to should be allowed to make a submission. So that's the amendment on page 57. Next, we move on to page 79, which is about the amendment in respect of the controller, Mr. Sin Chung Kai. I might have left this out. Well, it's the same series of amendment about actuary. Why is it that you have this whole series of amendments? Did you omit this originally? In the original drafting, we've taken this into consideration, except that we want to align the I think there is a procedure requirement for, and we are simply reiterating that procedure requirement here. Even in the original provision, for the insurer, if he wants to change the actuary, he would still need to inform the Commissioner of Insurance. But the original text doesn't state clearly that when the Commissioner of Insurance refuses that application, then what procedure does the insurer have to follow? Okay. Next, we come to page 80. And on top, you have the definition for controller. And in the middle, section 8 is a technical amendment because there was an omission at the drafting stage. In future, all appeals will have to be dealt with by the Insurance Appeals Tribunal, and therefore Originally, the FS should be the person making a decision on the appeal, and we have deleted that. So, okay. Similarly, subsection 9, that is same for section 9 on page 80. It amends 38E, deleting subsection 8, which is about the appeal provision. But again, this is provided for under a different provision. So this is simply to make up or an omission in the original draft. Page 82, you have 9 bracket A. Again, this is in response to a point raised by the legal advisor at an earlier meeting. This is a point about consistency. Here we said that we have added or is likely to be able to comply with the following requirements. The amendment aims at aligning the similar provisions applicable to intermediaries. You'll find this section there, and we are simply aligning it here. Sin Chung Kai. You say this is simply alignment, but I think it's very different. Why don't we give a microphone to Mr. Sin? I'm sorry, I'll speak closer to the microphone. I think this is different. You say here he has complied or is likely to be able to comply with. Well, either the person has complied or not complied with something. But you say, but I think but or likely to be able to comply with. I think this is very vague, this phrase. And it's a matter of subjective judgment. What do you mean by likely to be able to comply with? Chairman. This is to empower the IAA to conduct an investigation. So the IA may, in the light of some circumstances, may not know whether the insurer has complied with all the requirements, and therefore we have broadened the scope here and said that he is likely to be able to comply with such requirements, and then this will enable the inspector to conduct the investigation or the inspection. So where there is a suspicion, and this is about inspection. So you have to consider whether the person has the ability to comply. So he would need to check first, right?
One is not independent. It's not just whether the inspector is of such a view. In fact, if he is of such a view, then he will exercise the requirement under 2 and 3 for the production of certain things. Now you are going to make an amendment. Now if there's a case, you have to inspect, you have to check, and you don't need to consider whether he's able to comply or not. I don't think that is to broaden the scope. In fact, that is to relax the provision. If you have found that he is unable to comply with, so what? If I am able to comply with and I don't do it, then I am at fault. But if I am not able to comply with, then you will not catch me. I think that is a relaxation, rather. I don't know how to understand it. Chairman, with regard to the wording, it is similar to other provisions in other financial laws, say MPFO and also SFO. In respect of inspection, there is such wording. We apologize that there is an oversight. There was an oversight. Okay, is it okay? Let us move on to page 84 of the Chinese version, or page 95 of the English version. Now, when the inspector must have a copy of the appointment, and if the copy of appointment is to be produced, then is asked to be produced or required to be produced, and the inspector must produce that as soon as possible. And we move on to page 111 of the English version. There are two number 11 amendments. That is in respect of misconduct, the definition of misconduct in respect of an authorized insurer. And if there is a misconduct, then there can be disciplinary disciplinary action. Under page 96, we want to define that the misconduct does not apply to any contravention or acts before the date, the commencement date. So there is no retrospective effect in respect of this provision. We now move on to the amendment numbered 12, page 112 of the English version. In fact, in our paper given to the Bills Committee, we said that we would provide an opportunity of being heard, and that includes making written representation or oral representation. There is a square bracket number 13, which is on page 113 of the English version. That amendment is in response to a question by the legal advisor. This part, we were asked this, what did we mean by this part, and we spell it out, section 41P. And then over the page, we have the square bracket number 14 on page 119. There is a technical amendment. We are going to add how Part 13 applies to Lloyd's. We spelled out the various conditions and also the specified persons to be understood under the Lloyd's. We are now on page 106 of the Chinese version, or 123 of the English version. There is a square bracket number 15. Section 53A refers to confidentiality requirement. We just tidy it up. Some provisions which we left out are now added to the confidential requirement provisions. Page 107 of the Chinese version, there is a simple amendment, a textual amendment. Also page 110 of the Chinese version, another simple textual amendment. And then page 113 of the Chinese version is also a simple textual amendment. And now we are on page 117 of the Chinese version, or 135 of the English version, is the definition of an agency agreement. We just move the definition here. And then square bracket number 17, page 136, we cross out an individual and replace it by a person. After careful study, the controller of an intermediary can be a company or an individual. So we replace individual with a person to make sure that it can include a company. And then on page 141 of the English version, we have the amendments in square brackets number 18. We cross out deals with any matter that relates to and replace it by manages or controls any matter relating to. We've already explained that proposal at our previous meeting. That's in respect of restrictions on the staff members of a licensed insurer. And then over the page 143, technical amendments. And we move on to amendments with square brackets number 19, page 149. That is duty to notify authority of change in particulars. There is no need to report the fax number. To avoid overburdening the intermediary, we don't need to require the reporting of this. Why do you think fax number is not important? It will become a dinosaur very soon. A fax machine will become a dinosaur. Interesting. I don't understand it. Dinosaurs can lay eggs. Well, they are about to extinct. Okay. Square bracket number 20, page 150, and also page 1. It is in response to the requirement of the trade. Now, they were asked to inform the IIA before 1 month in advance. Is now changed to 14 days, and that is a textual amendment over the page. We are now on page 134 of the Chinese version, and also page 159 of the English version, a textual amendment. And then we are on page 138 of the Chinese version, which is a textual amendment. Page 139 Chinese version, also a textual amendment. Page 144 of the Chinese version, also a textual amendment to the Chinese. We are now on page 176 of the English version, square bracket number 21. The original 64 is set as is a provision for revocation and suspension of a license, which does not avoid or affect agreement. Now we have added subject to section 64N. 64N says that if a person, an intermediary, doesn't have a license, and the policyholder can choose to cancel the contract. Here we need to respond to that part. Page 150 of the Chinese version is a textual amendment of the Chinese version. 151 also a textual amendment to Chinese version. And then page 1553, the upper part of Chinese version, a textual amendment. In the middle, there is a bracket 3 amendment, which is corresponding to page 184 of the English version. It is to add the word reasonably. Page 155 is also a textual amendment for the Chinese version. Legal advisor, we've agreed with the drafting section 64 ZZB bracket 2 subsections 2, 3, 5, and also 7. The wording will be amended similar to that of in the same way as bracket 1. Yes, please tidy that up. We are now on page 160 of Chinese version. It's a textual amendment. On page 161 or page 194 of the English version, bracket 10 amendment must produce the copy if so requested. Now, set a bracket 1, there is reference to 41 capital B. There is an amendment which is on page 82 of the Chinese version. The bracket 1, the wording is the same. It's about the intermediary. 664 is ZF of the Chinese version. There is an amendment to the Chinese version. It's nothing to do with the English version.
好，161版。
Okay, please take that into account. We are now on page 194 of the English version. There's a bracket 22 amendment. Now, we did have a discussion. We now spelled it out very clearly in respect of the intermediary. Business premises means any non-domestic premises. Over the page, 174 of the Chinese version. Well, it's all right that it is non-domestic premises, but some intermediaries may work at home. Then a warrant can be applied for. If you gain access to a domestic premises, then you will, it will be stricter. All right, that's okay if you can get away in. Page 174 of the Chinese version, bracket 23 amendment, which is corresponding to page 210 of the English version. It is in respect of the relationship between the insurance agent's relationship with the insurer, or the authorized insurer's relationship with agent. Page 212 4BA, 4 capital BA. We are of the view that the court, in deciding whether the authorized insurer is liable for the act of the intermediary, or the agency, or the agent or not, a number of factors has to be considered. Mr. Chairman, we will make a technical amendment to put this, to include this flexibility. The court can consider different factors according to the circumstances of the case. If members do not have any queries, then after the meeting, we can provide the wording to members for reference. Yes, just a minute. Legal advisor, please. Thank you, Chairman. With regard to page 174, bracket 2, she's referring to the Chinese version. Now, there is the in the Chinese version, and the Chinese version, the use of numbering is not consistent. Some in one provision, an Arabic number is used; in the other, a Chinese number is used. So there's a need to make the numbering consistent. Yes, please make them consistent. Please go on. Page 176, section 68, 4BA. In bracket C, small c, we have consulted the drafting section. The Chinese wording is difficult to understand. Maybe the drafting section can supplement. Are they going? They say they are going to change the wording to make it easier to understand. Sorry, speakers not coming through. Now, the English version reads, the clarity and prominence of the disclosure is what a person would reasonably require for deciding whether to enter into any dealing referred to in subsection 1b. It's okay with the English version. The Chinese version, they are discussing how to change the wording to make it easy to understand. The English version is easy to understand.
Person will reasonably require for deciding whether to enter into any dealings. 咁其實中文可以
The Chinese version can be amended accordingly so that the provision will be easier to understand. Mr. Loke, legal advisor. Page 177 of the Chinese version and page still 217 and then page 180 of Chinese version.
Bracket 24. This is again a technical amendment to stipulate that originally during the specified period, the insurance commission, the broker will have to submit the following materials. We specify here that it should be within 6 months. And then page 181 of the Chinese version, it's the same batch of amendments. We now come to page 183 of the Chinese version, where you find bracket T. This is again a minor textual amendment. Page 184, 25. Earlier on, we've dealt with Lloyd's, so we don't need to make reference to Lloyd's again here. And in bracket 1, capital B, we propose to delete those words which are reference to Lloyd's, because we have some provision earlier which dealt with this. Page 185 and 186, and here we are proposing to add one section to allow the authority to grant exemptions to anyone who has complied with the requirements of Part 10, especially in respect of the licensing requirements for the intermediary, in order that the person will not violate the licensing conditions. We must point out that this exemption by the authority is temporary in nature, and that condition could also be imposed together with the exemption. Move on. We now move on to page 187, which is definition of controller. And this is actually in response to a question from your legal advisor. That is, what does controller mean in this particular context? Here we are spelling out that it means that it has the same meaning given by section 64F. Moving on to page 192, we have bracket 12. I think we've mentioned this before. That is, the opportunity to make a submission includes making written and oral representations. And then page 193, where you find bracket 27. Again, this is in response to the legal advisor's suggestion that we specify that it is in reference to section 80. Page 195, capital 21. I think I've explained this before, that unless otherwise specified in section 64N, that is, the policyholder may choose to void the contract. And we are simply making a consequential amendment here. And then page 196 and 97, it's about the code of conduct. As we've said in the paper dated May the 18th, we've explained to members before that we plan to move a CSA here to specify that any breach of the code of conduct in itself will not result in the intermediary or the person who appoints him or her, including the insurer who appoints him, or if he is actually a technical representative, the company which appoints him should not be, sued or prosecuted in any legal proceedings. So this is the original proposed amendments. Your legal advisor had been in touch with us earlier, and she asked us the question, that is, what happens if the intermediary is a technical representative, and any breach of the code of conduct by him would result in his company being sued or prosecuted in any legal proceedings. For the sake of consistency, we think that it should not, and therefore we will be moving a technical amendment to clearly stipulate that even if he is a technical representative who has breached the code of conduct, this in itself will not result in him or his company being sued in a legal proceeding. Mr. Chen Kim-bo, I think we're at the last meeting, I think we spent a lot of time discussing this point, and we debated whether or not we should spell out that the fact that intermediary includes both agents and brokers with different functions. We had a very long discussion, and we eventually decided that we would accept the government's drafting. But the Federation of Life Insurers have just written to the chairman. I think we've just received it today. Again, they are referring to the same point. And if I may read it out again, although it's in English, he said that the drafting should be to differentiate between the definition for intermediaries is to differentiate between agents and brokers. And for 89A, an intermediary should act in the best interest of the policyholder, but then you have to distinguish between the agent and the broker who have, and there are different requirements for the two, and so long as if they act reasonably, it should be all right. I think we've talked about this many times already, but many leaders, many senior management of the intermediaries have called me up about this point. If this panel, accept that there should be an amendment, that's so much the better. But I would also like to listen to the administration's response. Chairman, well, as members have pointed out, we've discussed this many times already. For the insurance intermediary, if you look at the paper last meeting, CB 855, we have already explained that this ordinance already defines, stipulate that insurance agents and insurance brokers are two separate categories. 64W and U stipulate that the insurance agent must be authorized by the insurer. So we believe that the provision clearly, define what is an agent and what is a broker. So therefore, we don't believe it is necessary to repeat all that in the Code of Conduct again, and making such a distinction between the agent and the broker. So we don't think that such an amendment is necessary. As I said last time, once the IIA is set up, it will issue guidelines for the industry as to how they may comply with the Code of Conduct. At that particular level, it will talk to the trade and as to how they will differentiate between the agent and the broker so that both they can comply with the Code of Conduct requirements. So to put it simply, we do not believe that there is any need to make an amendment. Well, I think the Undersecretary has put it very clearly. Other than saying that there's no problem with the provision in future, through the guidelines, the different requirements for the two types of intermediaries will be spelled out. I hope this will really help resolve the problem. But I think a legal advisor expressed her concern. Do you still have the same concern now? Thank you. In our discussion during the last meeting, I made the point that if under 89A, since we differentiate, we distinguish between the two in the Code of Conduct, but we do not differentiate the two different types of intermediaries in 89.1, that is not desirable. So yeah, it's still not desirable. Well, I think we have actually looked into this point with the DFJ. 89.1 is not just 89A. The Permanent Secretary already explained that there is already a Code of Conduct. Earlier, we've already had the distinction between agents and brokers. The Code of Conduct will define clearly the requirements for both. And 93A bracket 7 said that these codes of conduct, if the court were to consider such Code of Conduct, then it would have to consider the detailed enforcement of 89A. So we would need to look at the several, sections together. So having considered this thoroughly, we believe that the provision already have clearly given has already given a clear definition. Chairman, if I were to move as CSA, do I need the agreement of this panel? Well, yes, that has always been the practice. Well, in that case, if the panel agrees that we move an amendment, it would be best if our legal advisor could help us draft the CSA. Of course, you will have to draft the CSA yourself, and then the panel, the Bills Committee may discuss it, and then make a resolution to endorse the CSA, and then it will become the CSA to be moved by this panel. But if the panel doesn't approve your proposed amendment, then you can move your own personal CSA. So do we have to draft the CSA ourselves, or can we ask the legal advisor to draft the CSA, because this is an onerous task? Can you help him draft the CSA, legal advisor? Well, I think according to our procedure, if this Bills Committee agrees that it is for the panel to move the CSA, then I will be responsible for drafting the CSA. But if this amendment were not approved by the Bills Committee, then individual members can move their own CSA, in which case the amendment will have to be drafted by the member himself. So in that case, if the Bills Committee agrees, of course there might be a disagreement over this point. If there's no disagreement, then the legal advisor will draft the CSA, and it will not be necessary for me to draft the CSA before members discuss it. According to our legal advisor, if the Bills Committee agrees to move the CSA could be drafted by the legal advisor. But if the Bills Committee resolved not to approve the amendment, and you can still move the CSA in your own name, in which case you have to draft the CSA yourself. So that's why I want to take the first step. If this panel agrees to endorse my proposed amendment, that would be best. Can we make a decision now? No, I don't think we have a quorum now.
或者我哋因為唔一定喺呢個會決定㗎嘛。
We may not have to make a decision now, Chairman. I think we may not need to call a meeting. I think we can, deal with this by circulation, right? We will report to the House on the 19th of June. On the 22nd is the resumption of the second debate. The second deadline for notice is 27th. That would be the deadline for the moving of the CSA. 27. So what can we do? Chairman, the legal advisor has explained clearly that it is not appropriate for us to take this route. If that's the opinion of our legal advisor, should we insist on doing this? I hope members will consider that. I won't take up members' time here, and even after we finish with our meeting today, we can still continue to work on this. Well, my proposal is that we can shelve this point for the time being.
We'll have a meeting until 4:30. Maybe at 4:15, we'll decide whether it will be a CSA to be proposed by this Bills Committee. Legal advisor, would you explain this? I think this is the delineation of the best interests of the intermediary, the broker and the agency. In respect of Section 89, there are provisions on the integrity requirement of the intermediaries. Number one, the intermediary must act honestly, fairly, in the best interests of the policyholder. There has been detailed discussion. At the drafting stage, there was a detailed discussion. We also had a detailed discussion with the trade, and the trade has provided that a piece of legal advice given by the legal advisor on how to better draft Section 89. After careful consideration, we accepted the proposal of the trade, i.e., to add that just a failure does not in itself render the intermediary liable to any judicial proceedings. We've already given a letter. I find it very strange why at the very last stage we still need to reopen the discussion. Otherwise, we'll be engaged in endless discussions. We have discussed it many times before. The amendment is the final CSA after discussion. If the discussion is reopened again, then there will be endless discussions. Mr. Chen. Yes, what is said by the Deputy Secretary is the fact. There has been long discussions, but I want to point out that there is still a disagreement. The legal advisor on behalf of the Council is of the view that the way the law is drafted is not satisfactory. How can we ignore the view of our legal advisor? And please do not threaten threaten us as to what you will do. I think the legal advisor is just doing her part, and we are also doing our part. Now, if the legal advisor does not have such a view, I will not belabor the point. The administration has to balance the interests of the consumers and the insurance sector. I think the difference is in terms of wording, not in terms of interest. I agree with the chairman. Let us discuss other items first. According to my understanding, the legal advisor, well, I didn't know whether the legal advisor talked to the drafting section. The trade, in principle, accepted the explanation by the administration, and best interests would not be a reason for legal proceedings or judicial proceedings. And that's a matter of principle. Now the point is how the law should be written so that people have a clear understanding of the matter. In terms of the text, I don't know whether our legal advisor has talked to the DOJ. I hope that can be dealt with according to the principle set out or agreed to. I suggest that in the later part of this meeting, we will decide whether our legal advisor will draft the CSA on behalf of the Bills Committee and make it the Bills Committee's proposed amendment. And the text, would the text be given to the law draftsman to see if the draft is acceptable? If they find it acceptable, then they will adopt it as their CSA. If they don't, then we will move our own CSA. Well, I'm not clear about the issue. Can an explanation be given, a further explanation be given? And that's maybe the legal advisor can explain it better. Why you don't allow me to explain? Well, if I can't explain it clearly to you, then you can ask the legal advisor. I don't understand why you have not heard about the discussion. I think the issue is in respect of best interests. Among the intermediaries, there are two categories: the broker and the brokers and the agents. The agents represent the insurer. The brokers represent the policyholders or the insured. They have different positions. Therefore, the meaning of best interest is different to different parties. The trade is of the view that the law is not clear. The legal advisor is of the view that the text as it is drafted at present is not so satisfactory, and therefore an amendment should be made. The Bureau is of the view that the provision is very clear. Do you understand this? Maybe I can ask the legal advisor to explain that. Have you given this view to the administration? Now, concerning 89(1)(a), at our previous meeting, we had quite a rather in-depth discussion. I, myself, members of the Bills Committee and government officials expressed their views on the wording of the provision. Are you clear about it? Chairman, if I may ask a question, can the legal advisor explain? According to legal advisor, she does not say that the drafting is not good, but it is not satisfactory. I just want to know whether the present provision is hard to implement or there is any great inconvenience. What exactly is the problem? And is the proposed amendment necessary? Legal advisor, can you explain whether the draft proposed by the administration is not desirable or what? At the previous meeting and just now, I have explained that under 89(1)(a), if there is no separation between two different parties, then I will say that the wording is not desirable or not ideal. Under 89(1)(a), if there is no specific reference on which type of intermediary has to do what to achieve 89(1)(a), then it will become unclear. The trade has already expressed its view. The administration has given the undertaking that it will specify in the code of practice the things the different types of intermediaries have to do in order to fulfill 89(1)(a). As for 89(1)(a), as it is drafted, it covers two different groups. It is not ideal, but it is not unacceptable. Now she said that this is acceptable. And we have already moved a CSA in response to the demand of the trade. Under such circumstances, under such detailed discussions, we have come to such a conclusion. We don't understand why at the last moment we need to reopen the discussion. If we are to reopen the discussion, does it mean that we have to withdraw our CSA here? If that's the case, then there will be endless discussions. Mr. Chen Kim-po, I thank the legal advisor for the further explanation. Your last word is very important. It is not ideal, but it is not unacceptable. If you say so, then I am rest assured. At the start, it is not desirable or not ideal, and now with the amendments, this is acceptable, though it is not ideal. Now, if you spell out the two different categories of intermediaries, and then it is better. Now, the present wording, the proposed wording helps a lot, but if it is not safest, it's still acceptable. But that's okay. Now you study law at the DOJ, study law, you draft the provisions. You should communicate among yourselves. You shouldn't leave the final decision to us. Now, if you say that the previous wording, the original wording, is not good, and after amendment is acceptable, though not ideal. Now, we want to be perfect, but nothing is perfect. Even if the political reform is not perfect, we still want to move one step forward. Well, please, if you think that's okay, then I think we can end our discussion here. The most important thing is it will not affect us. Mr. Chan, our legal advisor has already stated it very clearly. She is of the view that from her own perspective, it is not perfect, but not unacceptable, not practicable. That is her view. The Bureau is the view that the provision is very clear. This is the view of the Bureau. Now, I make a decision. After such a detailed discussion, and I also see that the Bureau has conducted an in-depth discussion with the trade, and they have agreed that best interest will not be the grounds for judicial proceedings. And there will also be code of practice promulgated by the IIA, and that is acceptable to the trade. Now, we had a discussion at the previous meeting, and we also have a detailed discussion on best interests. The discussion is arising from the term best interests. The trade is very scary about the term best interests. The trade has made a number of proposals. Well, let me give you just an analogy. We think developers and agents, state agents, have to act in the best interests. You cannot say that the developer doesn't act in the best interests, and only the state agents who act in the best interests of the customer. In the future, if there is any legal dispute, the judge will judge according to the circumstances of the case. If Mr. Chan is of the view that the trade requires you to move an amendment, I hope you will consider that. Otherwise, we will not pursue this point any further. Okay, thank you, Chairman. Yes, please go on. Now, let us move on. There is another square bracket amendment T, page 239. We are now on page 239. 243 now. Bracket 29 amendment. This is to amend section 92. And that is in respect of the setting out of rules or code of practice. Practice 20, bracket 29 amendment provides that the IIA can set out circumstances and conditions under which a licensed intermediary may receive any property, so on and so forth.
Next, we come to 201. That is the IAT, the amendment in respect of the IAT. Amendment number 30. Actually, we have provided for the definition of parties here. And I'll explain this further when we come to the part. Page 204, a textual amendment. Page 205, that is bracket 31. This is, again, an amendment in response to proposals by members and the industry. That is, the tribunal may, with the consent of the parties to review, determine the review on the basis of written submission only, and that there is no need for any oral hearings. So we stipulate here that the tribunal may, with the consent of the parties to a review, make a judgment on the basis of the written submission only. Next, 216, that would be amendment number 32. Here we've deleted Lloyd's. As I explained earlier on, we already have a provision dealing with Lloyd's, and therefore we don't need to make a reference to Lloyd's again here. Amendment 33, this is to clarify that an insurance broker engaging in reinsurance will be exempt from the requirements under 78.3. Page 220. At the meeting held on May the 15th, we've already explained this point. This is about, well, in the light of the actual operations of the insurer, in carrying out its insurance undertaking business, if then the part he doesn't have to be a licensed intermediary, because his basically his function is actually in captive. He's a captive insurer. And to be for someone who is in a staff, an employee of an authorized insurer carrying out regulated activity, because the client would not be members of the public. Next, page 222, Amendment 35, again, at the meeting held on May the 18th, we've already explained to members that this point. Here we are clarifying, make a clarification. That is, if the corporation or commits an offense, then the persons in management will also be liable. And here we page 223, and this is section 124. That is for the IIA. It may, make a prosecution in respect of some minor offences. In response to members' request, we've deleted subsection 3. Subsection 3 provides the flexibility for the IIA, so that even if this employee is not qualified to practice as a barrister, it can still act as a prosecutor. But given members' concern, we agree that since the IA has its own in-house lawyers, therefore we have deleted subsection 3. Next, page 232. That is order in respect of levies. And again, this is in response to a suggestion by members. That is when the CE makes an order in respect of levies, who is the stipulated person. We have here clearly explained that it is our intention that the policyholder has to, pay that levy. And here we want to stipulate that the order would specify that it is for the policy holder to pay the levy. Members may note that we've also made some amendments. so that when the CE Council, we stipulate the powers under which the CE Council may make such an order in respect of different types of insurance businesses. Legal advisor, on page 232, I think I've taken this up with the law draftsman. Under 132 bracket 2, in the amendment you've added AA, AB, and AC. Apparently putting AC at the front, because here we are talking about the making of a regulation under delegation of authority. AA spell out provides for the levy and the amount. So logically, I think AC should come before AA and AB because that would be more logical. So I think the order should be reversed. We now come to page 242, which a member of the IIA's declaration of interest. And again, this is in response to a point made by members. Originally, we said that pecuniary interest would need to be disclosed. For non-pecuniary interest, whether or not they should be disclosed. Having considered members' views, as we explained to members before, we agree with your proposal, and we are now moving this amendment so that the disclosure will not be limited to just pecuniary interest, but rather all interests, which may affect the person's execution of his duties, in which case a disclosure would be required. Page 243 is the same. Again, we deleted pecuniary. The word. Use that from time to time. Amendment from time to time. Could you speak in the microphone? Use that from time to time. Amendment. I don't know how it's put in English. I don't quite understand this. Let's say there is no time limit. I mean, it could be 14 working days or what. But sometimes, I mean, these could be, points of contention in any legal proceedings. So which section are you referring to, Mr. Sin? We're on page 242, right? Chairman. Well, from time to time, there could be different interests. In English, the words are from time to time, and I think the phrase is used in many other legislation. So in other words, when the need arises, the person concerned will have to make the declaration. I'm sure you've checked, the other legislation that from time to time is not a phrase that is new to this bill. For 2A, B, and C, I think we've made reference of other legislation. 246. A textual amendment, we've added the word "and." Page 250, these two batches of amendments are textual amendments. Page 251, textual amendment at the top. 255, 256 is the same textual amendment. 257, 258, again textual amendment. We now come to 262. We've added "and director." This is to actually, to fill an omission earlier. 263 now. Earlier, in respect of the point about actuary, we've added Amendment 39 here, so that the decisions concerned could be the subject of an appeal. And then 40 in the middle is simply to tidy up an omission earlier. That is that is direction in respect of the affairs, business, and property of the authorized insurer. And this could be a cause for appeal. And then 256 and 266 is a consequential amendment. The amendment will be reflected in the ordinance because in Schedule 11 there are two provisions which will be combined, and we are therefore making a consequential adjustment here. So I'll explain this point when we come to that part in a while. 266 at the bottom right-hand corner, parties. Again, that is moved to the front. The definition of parties. 267 again a consequential amendment, and 269 Chinese version. Again, this is in response to a discussion of the committee earlier. That is, during the course of the appeal, the chairman or members, if there should be any change to the chairman or the members of the tribunal, how do we deal with that hearing? We've added provision in respect of such hearings. And that is, if the parties to the review agree, even if there is a change to the chairman or the members, the hearing will continue. But without the consent of the parties to the review, then the hearing will need to start afresh. Page 270 is a textual amendment. And next, we now move to 274, where you find another textual amendment. Next, 277. Transfer records from form authority to IIA. Again, this is in response to an inquiry by your legal advisor earlier. That is, when will the transfer records stop? We say that the transfer would need to be completed on the date of commencement date of this ordinance or before. And then 278. Amendment 44, this goes all the way to 280. The purpose of the amendment is to deal with the transitional arrangements, that is, appeals which have been lodged to the FS. But because of the commencement of the bill, how will this migrate to the tribunal? 278 provide for the specified decisions. That is, under the original legislation, these are the grounds for appeals to be lodged to the FS. And to 279, that is, with the commencement of the bill, if the FS has not yet made a decision, then the case will be referred to the IAT to handle. And then 3(c) stipulate appeals not made to the FS before the commencement date. And because of the commencement of the bill, then he can only appeal to the tribunal. And the FS, in dealing with this appeal, the tribunal rather, in dealing with this appeal, will need to make the same reference and consideration as before. Next, 281, a textual amendment, and 282, amendment number 45. I think in a while you will see amendment number 45 again. Well, these are actually transitional provisions to ensure that the transitional provisions are more precise. Originally, we say, until the commencement date, but a day could be a long time, could be morning or the afternoon. So we've changed it to, the time of commencement.
全日咁究竟
That is more precise. Page 283 of the Chinese version, or page 346 of the English version, expiry date becomes the time. As for bracket 46 amendment, page 347 of the English version is also a transactional arrangement. This is in respect of a deemed license. That is about the effective period of the deemed license. Having considered the various factors, we propose to add that if the decision is confirmed by the tribunal, but the person appeals to the Court of Appeal, and the Court of Appeal reverses the determination, then the effective period of the deemed license is set out under bracket 46 amendment. And then from then on, you can see the bracket 45, bracket 46 amendments over the following pages. All the way 384, 305, 348, 349 of the English version, all the way to 354, 356, and also 358, and also 359, 360 of the English version, and also 362 of the English version, and also 364 of the English version, 368 of the English version, or 303, 304 of the Chinese version. They are similar provisions. They are the same amendments. And also 370, 372. They are the amendment of 45 and 46. And then there is a bracket 47 amendment, which is 69A. 69A deals with the application of Section 64 to companies applying for deregistration. Now, if a company on ending its business has to provide information to the IIA, but if the information is provided before the commencement of this bill, then how can the application for the registration be dealt with? We have this amendment under bracket 47. If the application has been lodged, it remains in force, and it will be dealt with by the IIA, and the IIA may ask for further information, and the company will have to furnish such information as required. Followed the same is then followed by 45 amendments, bracket 45 amendments, 46 amendments, all the way to 394. On section 90, subsection 1. 90 bracket 1 bracket B. The legal advisor refers to the Chinese version and asks whether the word "and" should be added. The word "and" is present in the English version. At the start it says that there is an implied meaning in the Chinese that so that the word cup is not necessary. Pages 394 is a number 46 amendments, 395 and number 45 amendments, 398, 397, 398 and number 45 amendment. And then on page 404, it is a number 48 amendment, and it should be read together with the following pages. Bracket 48 amendment is to tidy up the wording. Now, originally there were two parts. It is about an outstanding complaint or an outstanding investigation. We have looked at the provisions. Since the wording, they refer to the same things, we merged the two together. We call them a contravention. The contravention includes an outstanding complaint or an outstanding investigation. Now, the wording is an allegation, an alleged contravention. If it is not completed before the commencement, then it will be taken over by the IIA. They are bracket 48 amendments. And then on page 331 of the Chinese version, they are textual amendments. And also bracket 45 amendments. We now come to part 8, page 412 of the English version. There is a textual amendment. And over the page, there is a number 48 amendment. And we now come to 330, page 339 of the Chinese version. Which is just an amendment to the Chinese version, a textual amendment. This is part 3. Now on page 339, the Chinese version, or 420 of the English version, reference is made to Division 1, Cap 1, Subleg C. Public Offices Notice. The Chinese is 指定公告. It should read 指明公告 rather than 指定公告. That's an amendment to the Chinese version and not to the English version. Over the page is a textual amendment. 479, a textual amendment. And then page 392 of the Chinese version is a textual amendment. And that comes to the end of the CSAs. Last Friday, there was a new legal notice, and that is about limited liability. And that's also reference is made to some of our provisions. And we also need to have consequential amendments, but this is really technical. After the meeting, together with some of the outstanding CSAs, we will submit also this CSA for your reference. Now, we have studied the CSAs proposed by the administration so far. I just want to ask members, with regard to the proposed CSAs, do members have any objection? Our legal advisor has pointed out quite a number of places where some tidying up has to be done. They are not about mistakes. They are just about, they are not legal mistakes. They are just textual comments which have to be tidied up. There is no policy dispute. Even with regard to the point on best interests, after discussion, a compromise has been reached. So after you have tidied up the text, I just want to ask members whether you want them the text to be circulated. Mr. James Toh, I was listening to this meeting when I attended the meeting next door. I once asked the administration on Section 68 the proposed CSA to 68 may have missed something. If the insured can prove the court that the new provision on exemption should not apply, that is, Section 68 should be applied, then such an amendment should be added. I think the administration is considering this point and has not replied to me. I don't know whether I have missed the discussion or whether the reply has been given to me. Yes, the administration. Right. We have talked to Mr. James Toh with regard to ABC, the exclusion of legal liability. We've all agreed. We will provide, we'll add a provision. The court can consider other factors, and if the court considers it reasonable, the court can refer to other factors. We discussed that yesterday. We are discussing with the DOJ on the wording. We have reported that the draft CSA will be given to the Secretariat for your reference. Chairman, I hope that there can be a short meeting to discuss this item. We need to be fair to other colleagues. Earlier on, I raised this proposal. The chairman and other members are aware of this. But whether the specific provision can balance, can convince other members. Do you accept the point proposed by the administration? Yes, I suggest this. You accept this? Yes. You want a meeting to scrutinize the provisions made by the Bureau. Well, we still have one more meeting slot on Friday, 10:45 in the morning. Will you be able to meet the deadline? I agree with Mr. Toh. Okay, try to hurry then. Now we will produce a draft and then circulate it among members. If there is a need to call a meeting, then let's call a meeting. If you don't need to call a meeting, let us fix a date for the meeting, and then they circulate the paper. If after reading the paper, we tell the chairman that we don't need the meeting, then you cancel the meeting. Today is the 2nd. The date of next meeting is May. If you tell me to cancel the meeting in the morning on May, on the 5th of June. Chairman, well, okay, let's fix. Let's circulate. If you ask me, yes, let's fix the meeting date, the 5th of June, okay? The 5th of June. I believe it will be the last meeting. Let's have a good end then. Okay, the 5th of June, 10:45. Date of next meeting. Okay, finish. Hand in your homework before Friday then. Okay, let's have a brief meeting on Friday, and then tie up the loose ends. All right. Okay, we have our meeting on Friday. We don't need to change the timetable. We'll not change the timetable. Resumption of second reading is the 8th of July. Is it the last sitting? Yes. And then the deadline for making a report, the 19th of June. Deadline for making the notice for second reading resumption, 22nd of July. A deadline for moving CSAs, 7 days before that, and that is the 27th of June. That is nothing on the AOB. Date of next meeting, 2 days from now, the 5th of July, 10:45 a.m. Hope that we can finish with it quickly. And please tie up the loose ends. Okay? Yes, let's have one more meeting. Okay? The meeting is now adjourned. We are 15 minutes earlier.